So the first case is State of Ohio versus Kevin Toy. That's 19CA011476. Each party will have 15 minutes to present its arguments. Appellant may reserve up to 5 minutes for a rebuttal. If you plan to reserve time, let me know before you begin your argument, and I'll do my best to try to track the time for you and keep you apprised of the time. The arguments are being visually and audibly recorded. We have read your briefs and we are ready to proceed when you are. And Ms. Bremke, you are the appellant here, so you can go ahead and proceed whenever you're ready.
Thank you, Your Honor. Giovanna Bremke on behalf of Mr. Toy. If it may please the court, if I could reserve 5 minutes of my time for rebuttal.
All right.
Mr. Toy was convicted of trafficking and possession with the major drug offender specifications as a result of a traffic stop in July of 2015. He was convicted and sentenced to the 11 years of mandatory time according to that specification. The three assignments of error are the first related to the motion to suppress, and then a sufficiency and a manifest weight argument. Most of my time I'll focus on the suppression and the credibility of the troopers who had testified. These troopers, and I know you're familiar with them because they appear in many cases, which I've cited in my brief, Trooper Laughlin and Trooper Trader. In fact, there was a decision out of this same court, the Lorain County, and also went to the 9th District, the Assad case, which said that those same troopers were not credible. There's other cases, the Davis case, Jackson case, in which the very similar situations to what happened here. There's a minor traffic violation, and again, these are very minor violations, none of which are ever captured on the video and the dash cam video. And again, the Davis case and the Jackson case are similar to that. They're the exact same troopers in those cases. It's this exact same exit on the highway, and it's essentially not credible at all. These troopers testify that they have about 80 to 100 of these major drug arrests every year. And when I'm talking major arrests that lead to mandatory imprisonment under MDO specifications, not just minor possession. These are large offenses. And repeatedly, they're asked in every single case, why isn't this violation captured on video? And is it possible that it could be captured on video? And what this...
So I'm going to interrupt you just for a second because obviously I've read your brief and I know what you're referring to, but at the same rate, how are we supposed to consider, you know, these other cases? And you say that they've said the same things and so forth. How are we supposed to consider that in our record here?
Yeah, so it's an interesting argument because I'm really asking you to rely on the facts of those cases, not necessarily the legal holdings. But I think, it goes to the credibility issue in this case. These troopers, is time and time again, and it's the same set of facts and the same lack of credibility. The trooper testified that about 50% of his citations every year were these major offenses, and that's in transcript page 54 of the motion to suppress hearing. 50% of the time were these are charges that carry with them a serious mandatory prison sentence, and time and time again, there's no way to corroborate the very minor traffic offense that leads to mandatory time in prison, and nothing to corroborate the testimony. In fact, they admit to that. That's transcript page 67. He says, no, there's nothing to corroborate my story. They're also asked, could you switch it to a manual mode? Because what happens is, when they turn on their lights, then the video starts, I believe it's 60 seconds back. So the troopers know this, and intentionally, although there's no traffic on the highway, they don't pull out until much later. And it takes a while, and this is all testimony that's in the record, that's in the motion to suppress hearing. It takes a while for them to catch up to these, to the vehicle. And when they, and the reason for that being that it's an automatic, retroactive camera, 60 seconds. Now, they're saying the defense attorney asked, can't you manually switch that so that it starts? So that, you can say, okay, I want it to go retroactive and I want it to start at a certain time. And there's testimony that it could happen. But yet time and time and time again, these minor violations, which is significant, especially in this assignment of error, deals with the motion to suppress. The stop's not valid. The rest of this is really, we never get to the jury trial, in my opinion. So that's the most significant thing. And
well, counsel, going back to what Judge Carr said, because I want to make sure I have this right. These cases that you're talking about in the brief, did trial counsel bring them up during the suppression, like as part of cross-examination? Were they put in front of the trial judge?
No, they weren't, Judge.
Okay. So then I guess I'm going to go back to Judge Carr's question. How are we supposed to consider those facts that you're telling us?
Well, I think they are, their cases, they're appellate decisions out of this court. So it's not like they're decisions that were, trial court decisions that were never published. They are decisions, and those facts are in those decisions. Other issues of credibility is the trial court actually admits that the trooper, that it's a different, that his testimony was different on the day of the suppression than it was in his report. That's transcript page 141. In fact, he says, and it's a quote, "There's certainly some uncertainty and ambiguity or even contradiction between the testimony of Trooper Laughlin that he gave today and his written report that he prepared 2.5 hours after later, where he said that in the report that it looked like he saw a lane change as he pulled out to follow the defendant's vehicle. And then at the suppression hearing, it was that he was traveling below the speed limit. That's not documented in the report. And the trooper says that that these are traffic violations that occurred, that his memory is better 19 months later. That's transcript page 85 than it was on the day of the stop. So again, not only is there issues with the fact that it's not captured, his testimony isn't reliable. And that goes straight to his credibility. That they, again, that there's, how can it be credible when we don't have anything to corroborate it, and even his own testimony lacks certainty? By admission of the trial court judge, he agrees with that. The other issues that were presented at the motion to suppress were issues about breathing heavy and nervousness, and those being indicators. The Assad case, again, that trial court judge said that not only are those not shown in the video, which again is the case here, but it also lacks credibility that the troopers had said that, because it's something that is not able to be corroborated. Again, all of these items that are things that are unable to be corroborated. And when we're looking at this, we're looking at the totality of the circumstances and what altogether what their testimony is, and how it lacks credibility, not just in the one area, and not just in the fact that even if you aren't able to consider those other cases, and but just his own testimony and what the trial court says, and the trial court's statements that the trial court says, without a video recording of everything, I don't know for sure who got it right, is what he says. That's transcript page 143. And that's problematic because the state has the burden in these suppression hearings. So again, this is a totality of circumstance situation where the trial court erred when it didn't grant this motion to suppress. The other two assignments of error, one is sufficiency as far as the possession and trafficking, the knowingly element, that there has to be a knowledge there, and there was no testimony that would link Mr. Toy's knowledge to the possession. There's actually two gentlemen in the vehicle, not just Mr. Toy. And lastly, a manifest weight. Again, this goes back to the fact that there is no video at the trial, not at the suppression, at the trial testimony. The defense attorney asks, isn't there a way where you could have, recorded any interaction or audio recorded, video recorded, any sort of admissions that my client had allegedly made? Because again, there's this, after the stop and after these drugs were found, then there was a conversation held, and none of that is captured either. Despite the fact that there's 80 to 100 drug busts in this same exit, these same troopers, they all go back to the same maintenance garage to be interviewed, and the defense attorney asked, well, why couldn't you preserve that evidence? That's important evidence. And he says, well, there's other troopers that have that equipment, but I didn't have that equipment available to me. And again, for somebody who 50% of his arrests every year lead to major imprisonment and major incarceration, it's not credible to believe that he wouldn't have access to that equipment. I do want to point back to my suppression argument. Okay.
Just so you know, you're into your 5 minutes, but you're free to go ahead.
Okay. One other thing I forgot to mention, as far as the suppression goes, there's another important information that the troopers were communicating with each other. And this is transcript page 53. There's communication between the troopers. One allegedly sees the vehicle, communicates to the other to watch out for it, and then the other troopers later down the highway. That communication is not preserved at all. And again, this is time and time again, this same set of facts where this evidence isn't preserved. And it's important from a defense standpoint that without this preservation of evidence, it lacks the credibility from the troopers that if they didn't preserve it, what are they hiding? And again, that's a credibility issue. So I would reserve the rest of my time. Thank you.
All right. Mr. Murphy, whenever you're ready.
Thank you, Judge Callahan. Good morning, Judge Hensel. Good morning, Judge Carr. Brian Murphy, Assistant Prosecuting Attorney, Lorain Prosecutor's Office. What Mr. Toy essentially asks this court to do is disturb the trial court's credibility determination regarding then Sergeant Laughlin's testimony about the basis for the traffic stop. That is not not only shouldn't this court do that, but this court can't do that on the record before it. The record before this court is testimony from Sergeant Laughlin that a traffic violation occurred, that Mr. Toy was driving the vehicle when the traffic violation occurred. The traffic violation gives probable cause to stop Mr. Toy and the vehicle he's driving. It was a constitutional stop. The testimony for the reason for the stop is in the record, and the trial court judge found the testimony credible. He said, I find the testimony credible on page 143 of the transcript. It's really that simple. There's a basis for the finding in the record, and there's no reason for this court to disturb the credibility determination that the trial court made because it's based on something in the record and a legally permissible reason. Judge Callahan.
Counsel, I'm sorry, before you get into Judge Callahan's question or whatever, we have to defer to the trial judge just because there's something in the record, do we? We still have to look at whether there's competent, credible evidence.
And I'll answer that by answering the question, how are we supposed to consider these other cases? And my answer is you cannot, because it's not what Mr. Toy actually is asking this court to do is to consider impeachment evidence that was never placed before the trial court. That's absolutely improper. Sergeant Laughlin is not here to defend himself. You cannot impeach a witness in an appellate brief. And that's what Mr. Toy's asking you to do. He's bringing facts into this case that were never placed before the trial court, and the trial court judged credibility without them. If defense counsel wanted him, the trial court, I should say, wanted the trial court to judge the credibility based on these 3 prior stops that are in appellate opinions from this district, then trial counsel should have cross-examined Sergeant Laughlin using that information. But he didn't do it. And you know why he didn't do it? Because there was no reason to do it. Look at the Jackson case. The court upheld Sergeant Laughlin's stop in that case.
Could I stop you before you get into all those cases? Actually, I was more concerned with my question, and maybe I didn't word it the correct way, was we don't have to defer to the trial court just because there's some evidence. It still has to be competent, credible. So my point is, if the videotape completely contradicted what an officer is saying, and the court said, well, I find the officer credible, we wouldn't have to defer to that trial court because we could say, well, the videotape shows the exact opposite. So that's
Absolutely correct, Judge Carr. Yes, I agree with that.
Okay.
But
so I just wanted to make sure we were on the same page, because
sure,
it's not they're deferring to the trial court just because there's some evidence. Some evidence is not going to be sufficient.
Agreed. I do agree with that, Judge Carr. And if you're looking at any video evidence regarding the stop in this case, as has been pointed out, it's the video does not, by the way, you can't look at the video with regard to the motion to suppress, I don't believe. The state doesn't believe that. And here's why. No one asked that it be made part of the record as far as the motion to suppress goes. It's not part of the record. Defense didn't ask for it to be made part of it, and the state didn't. So I want to make sure we're clear here. It may be part of the trial record, but it's not part of the motion to suppress record, as far as I can tell. And maybe when you look through the record, you'll determine that differently, but just because the video gets made part of the trial record doesn't mean that it's part of the motion to suppress record, I guess. I have no reason to say that it is. You still have to ask that it be made part of the record. If the court's going to determine that it's part of the record, then it should do what I did, which is the video goes back 90 seconds, by the way, in time. From the time that the sirens and lights come on, 90 seconds was the testimony, not 60. And the judge heard all these arguments. There's also an allegation that the trooper here in the briefs and argument that Mr. Toy puts to this court, that the trooper intentionally delayed the stop. And without the video being part of the record, there's no reason for this court to conclude that. And if the court wants to make it part of the record for whatever reason, I'm going to tell this court during this argument here that the video shows that that's not the case, that he did not intentionally delay the stop. He was caught up behind other cars and got behind Mr. Toy's vehicle, it would seem from the video, as soon as practicable. So really what the trial court, and I guess to go back to Judge Carr's question, what the trial court was left with was Sergeant Laughlin's testimony. And to some extent, Trooper Trader's testimony. And that's what the trial court was left with. The trial court heard all these arguments that Mr. Toy's putting to this court, and the trial court nonetheless found that Sergeant Laughlin's testimony was competent, credible evidence, and that there was no other evidence, and no one's put forth. That's the thing. No one's putting forth, Mr. Toy, I should say, is not putting forth any evidence that is different than his testimony. There is no evidence that contradicts what he testified. So, Judge Carter, in relation to your question, that contradiction in evidence isn't there. There was cross-examination, and there's been allusions casting suspicion on the testimony, I guess you could say. But the trial court heard that argument and didn't buy it. And by the way, the trial court also heard testimony from Mr. Toy during the motion to suppress hearing and was able to compare the testimonies and determine which was the more credible. The cases that Mr. Toy cites in his brief, Jackson, Davis, and Assad, essentially there's a reason that those cases aren't brought up to Sergeant Laughlin during the motion to suppress hearing, and that's because his answer would have been, my stops were upheld in 2 of the 3 cases, and the appellate court was basically telling the trial court, you were wrong in Assad, or I'm sorry, this court did tell the trial court, you were wrong in Assad. That's what this court told, that's what this court held in all 3 cases. What can we take from those cases? All the stops that Sergeant Laughlin made were constitutionally permissible. That's what we can take from that. And they're not part of this record in any way, shape, or form. And I go back to the point that it's entirely unfair to Sergeant Laughlin to raise these cases in an appellate brief where he doesn't get to defend himself. And the state doesn't get to defend Sergeant Laughlin's 3 stops that occurred over the course of, Mr. Toy can't even tell you over how much time. It's just, there were 3 stops. Like they occurred within 3 weeks of one another. These cases were handed down by this court over the span of something like 3 or 4 years. You're looking at like on average 1 stop a year then. The court also in Davis, what we can take from that, the court basically went so far as to say that the lack of video survey, the lack of dash cam video was basically immaterial. It wasn't there, so there was nothing for it to consider except relative to credibility. And this court upheld the trial court's denial of the suppression motion in that case. Judge Carter, just one other point to answer your question. I mean, yeah, that's the Alley case that's set forth, that's cited in Mr. Toy's brief. It's a 6th district case. But as the state points out, in that case, the trial court found that the testimony was incredible. The trial court said, this is why it's not credible, and essentially said, look, the dash cam contradicts what the officer said. And so it didn't give any weight to the officer's testimony because it had video evidence of what had occurred. So sure, if that evidence were here, obviously there'd be an issue, but that evidence in the form of dash cam is not before this court. 2 other things I'll just point out with regard to the sufficiency argument and the manifest weight argument. There was a confession, and with regard to Sergeant Laughlin not recording the post-arrest confession, frankly, you probably have a better confession in this case than in most cases. You have a real-time confession when you watch Mr. Toy sitting on the bumper of a car, I believe, or in the back of one of the state trooper cars, basically narrating Sergeant Laughlin getting near the drugs. He clearly knew where the drugs were. that in real time corroborates the confession, the admission that Sergeant Laughlin testified to post-arrest, whether it's on video or not. You're actually getting one before Sergeant Laughlin even found the drugs. The last thing is again, with regard to the manifest weight, going back toward the two different records in the manifest weight argument, there's a reference back to the motion to suppress argument, which again is improper because there's two different records there. In addition to this court's view that basically we shouldn't be referring back to prior assignments of error and arguments made under those, but they're also different records. They're different records upon which decisions are based. In the absence of any other questions, Judge, the state asks that you affirm the trial court's judgment regarding the motion to suppress and also affirm Mr. Toy's convictions. Thank you.
Any questions?
Yeah.
Ms. Bremke?
Yes, I wanted to correct a couple of things that the state just said. One was that the video is going to show that there was no intentional lapse and that there's no record to suggest that there was intentional lapse in leaving the stop to apprehend Mr. Toy, and that's explicitly not true. In fact, there was talk on page 63, 64 of the transcripts in which defense attorney asks and the trooper admits that there was a long pause, that there was no traffic. So the state presents it as if there was traffic and he was caught behind cars. But there's actually explicit testimony that says there's no traffic. There's also testimony where the defense attorney says, why weren't you prepared to stop this vehicle when your coworker had called you and said, which we don't have any record of, but he admits that his coworker had tipped him off that there was a suspicious vehicle. So why weren't you prepared to pull this vehicle over? And he basically says, I don't know, maybe I didn't have my seatbelt on. It takes not 90 seconds to put a seatbelt on. It's all a credibility issue. And in Assad, this court overturned and sent back, in the trial court again upheld that, declared that that stop was unconstitutional, because it is. What these troopers have done is create a black hole of unconstitutional stops in this same area, in this, in your jurisdiction, and they're completely incredible when they're on the stand, and that's exactly what happened here. This entire motion to suppress, the testimony is all over the place. It's not credible, and the trial court admits it's not credible. He says he's uncertain at what happened and who got it right. That right there says if you're not certain about who got it right, then the state didn't prove their case. And for those reasons, we would ask that you that you reverse it back to the trial court. Thank you, Your
Honors. All right, thank you both for your arguments. We'll take the matter under advisement, issue a written decision in due course. It will be mailed to both sides as well as posted on our website and that of the Supreme Court.